in this
On my
case?
grandson's side?
No, just was Child Protective Services involved at all in any of these cases?
I believe I heard that they were, yes.
All right, does he only have, oh, it's two
We have
cases?
two companion cases virtually identical and no
Okay,
allegation.
just one moment.
I have
Oh,
extra
just-
copies.
Oh, they attached it.
Of motions? Yes.
I have extra copies.
Okay.
They're virtually the same.
And just give me a moment. I'm waiting for Odyssey to pull up your case for me.
Sure.
And the circles are going.
Waiting on Odyssey. I don't think that's ever been said before.
You have heard a lot of secret.
Mhm.
An intervention.
That says loading case summary. All right, there we are. All right, and you want to change the conditions, correct?
We have a couple of conditions that we would like to address due to how long the case has been on
All right, well,
bond.
let me ask you this.
Yes,
Have you
ma'am.
conferred with the state on this?
I have.
And are you in objection?
We are in objection, yes, Your Honor.
All right, so we'll go on the record. Just give me a moment. All right, if everyone can please whisper, we're going to go on the record. Please make sure that you're not talking behind the court reporter. If you wish to speak to your client, just ask the deputy to remove your client to the other end. 118261, State versus Christopher Ray Munoz. Can I have parties announce?
Rick Pena for the state of Texas.
Ben Stevenson for the defendant.
And are you Christopher Ray Munoz? In each of these cases, the defense has filed a second motion to modify special conditions of release on bond. State, have you had a chance to review the motions?
I have, Your Honor.
And state, are you in objection?
We are, Your Honor.
All right, defense, you may present evidence. Do you have any witnesses?
We do, Your Honor, but before that, I do have one housekeeping matter, just simply a request.
Mhm.
We had a similar hearing on October the 24th. During that hearing, special concessions were made. The names of minors were mentioned and their addresses, home addresses, one of which was on a military base.
Mhm.
We found out later that
Okay.
the court proceeding was being broadcast live on YouTube.
Mhm.
And the persons named and the addresses ended up being targeted for harassment.
Mm,
by
that will be
persons after
removed.
that. So we would ask that no names of minors or no addresses would be put on YouTube
Yes.
today.
All right, and that will be removed. And if it was, it's because it's listed as public information in the motion. So, counsel, in your motions, it would probably be best for you to just list them as complainants instead of the names, if
Okay.
they are complainants.
They're not.
All right.
I have mentioned three persons who are under 18, who are close relatives of the defendant, who are not involved in this case in any way, but who are affected by defendant's prohibition at being around any person under 18, which is one of the things that we'll address today.
All right.
That's the only housekeeping matter.
All right,
We
so
have
then
one witness.
you may want to file motions because these documents are public record.
Okay.
So you may want to file motions to have those names removed from the other motions that have previously been filed.
I understand.
All right. Yes, who is your witness?
The defense calls Mary Munoz. Mary Munoz.
All right, Ms. Munoz, and sir, if you'll stand to this side. And counsel, she does not need to mention the names of the minors. I've read it in your motion.
Yes, Your Honor.
All right, can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
Mary Williams.
All right, just make sure you speak up because the court
I
reporter
will.
needs to hear. All right, defense, you may proceed.
Hello, Mary. Would you like me to call you Ms. Munoz or Mary? What would you be more comfortable with?
Mary's fine.
Mary is fine. Thank you. Okay. What is your relationship to Christopher Ray Munoz?
I'm his mother.
Did Christopher grow up in your home?
Yes, he did.
Does Christopher currently reside in your home?
Yes, he does.
Are you aware that Christopher was released on bond in March of 2024?
I do.
Okay. And has he lived in your home at all times since his release on bond over a year ago?
Yes, he has.
Okay. Are you aware of the nature of the charges that he is charged with?
I am.
Are you aware that he currently is subject to bond conditions preventing him from being around or in contact with any person age 17 or younger?
I am.
Are you also aware that he is subject to a bond condition requiring him to be on GPS monitor with the exception of pre-approved work and of court proceedings? Are you aware that he is restricted from travel for those two reasons only, with the exception of a 2-hour shopping allowance that the court has given him in October?
Yes.
Okay. Wanted to ask you a couple questions. Do you have relatives who live outside your home?
I do.
Are these relatives that you keep in touch with?
Yes, I do.
Do some of these relatives have children who are under 18?
Yes, I do.
Would you like to be free to have these persons, including their under 18 children, be able to visit you freely in your home?
Yes, I would.
All right, let me just one moment, if we can go off the record. So state, it appears that from the defense's motion, what they're requesting is that for Easter, he allowed to have contact with his minor son, nephews to celebrate Easter dinner at the defendant's mother home where the defendant resides. So my question is, that's what it says in here. Defendant is aware that the Easter holiday is coming up on April 20th, 2025, and the members of defendant's family, including his minor son and nephews, desire to celebrate Easter dinner at the defendant's mother home where defendant's resides. If it pleases the court, defendant seeks release from the above bond conditions in accordance with this motion in time for Easter 2025. So my question to the state is, are you going to have objections, bearing in mind what the court has previously ruled? Are you going to have objections with him being supervised with minors for Easter?
I am, Your Honor, yes, because we feel that. the
Okay, no,
charges-
no, I'm just,
Oh, yes.
yes,
Your
okay,
Honor,
then you
that
can
is not
continue.
all that we're asking for.
All right, you may continue.
Thank you, Your Honor. What is the nature of Chris's employment? Is he currently employed?
Yes, he's employed. Yes.
What type of work does Chris do?
What time is
What type of work does he do? What does he do?
doing
for a
right
living?
now? He's a press operator.
I'm sorry,
A
what?
press operator.
Can she speak up? I can't hear.
Yes, if you could speak up.
Press operator.
A press
Press
operator.
operator. Okay, thank you.
So would you say that that is an industrial job?
Yes, it is.
Okay. Does he have work history or capabilities that include other types of skilled labor?
Yes, he does.
Okay. Has he ever done carpentry work?
No.
Has he ever done maintenance work?
Yes, maintenance.
Are you aware of whether he would have other opportunities outside of his normal job and his normal work hours? Should he be able to accept them? Are you aware of whether other opportunities exist?
There are, but currently he's not able to accept them
Do you know why he's not able to accept them?
because of his GPS, because of his monitor.
Okay. Now, he has permission to work.
To get permission.
Is it the fact that he can't get approval fast enough? Or what is preventing him from accepting other employment options? Do you know?
That fact of, he has to give,
Okay.
advance.
Do you know how long it takes him to get approval to go places? How many days that's taking?
I do not.
And during the last year, you said Chris has lived in your home, correct?
Correct.
During the last year, have you seen any behavior by Chris that would cause you to question the safety of any person under 18?
No, I haven't.
Have you seen any behavior from Chris that would cause you to question whether he's going to stick around for trial?
No, I haven't.
Have you seen Chris break the law in the last year?
No, he has not.
You seen anything that Chris has done or discussed that would cause you to be concerned for the safety of the community?
I have not.
Okay. Are you aware of whether Chris has gotten in trouble for violating any of his conditions of bond since he's been on bond? Do you know of any time he's violated?
No, he has.
Okay.
I do not.
Now, it would be easy to ask for relief just for one day. But you said that Chris has been on house arrest for over a year now.
Yes, correct.
So would you like Chris to be able to travel freely within Bear County?
Yes, I would.
Why? Why is that important?
It's important because he needs to stay, for his well-being and his mental
Okay.
state.
Now, are you concerned that he would go around the persons who have accused him in this case? Or are you concerned that he would go around them?
I am not. No.
Okay. And are you concerned for the safety of any of your minor relatives if he would be allowed to freely associate with them?
No, I'm not.
Okay. Do any of these relatives of yours ever have get-togethers at their homes, not at your home?
Yes, they do.
Okay, and are some of the children under 18 present at those gatherings?
Yes, they are.
Would you like for Chris to be able to go to those gatherings as well?
Yes, I would.
Do you think that it is healthy for Chris to be able to be at these family gatherings?
Yes, I do.
Okay, and do you have any concern if he is allowed to go to these family gatherings? Do you have any concern for anybody's safety?
No, I do not.
Pass the witness.
State?
Just a few questions. Ms. Munoz?
Yes.
You mentioned earlier you are aware of the charges pending against your son, correct?
Yes, I am.
That there are two separate cases pending against him?
Yes, I am.
And are you aware that these charges involve complainants under the age of 14?
Yes, I am.
Despite knowing that you said you're feeling okay with him coming into contact with children under the age of 14?
Yes,
Okay. Now, you testified that you were wanting your son to have contact with his son and nephews at your residence for Easter Sunday. Is that correct?
yes.
Is there no other means that you can think of for this to take place other than at your residence?
Well, he wouldn't be able to see them if they were somewhere else, right?
Well, could you go and see?
Well, yes, but the purpose is for his son to see him. Because he hadn't seen him since Christmas.
No further questions, Your Honor.
Redirect, Your Honor.
Yes.
Ms. Munoz,
Mhm.
did you know that you are free to go visit your grandsons anytime you want to?
Yes,
Did I understand correctly that your concern was not so much that you're being isolated from your grandsons, but that Chris is?
yes. More Chris.
Before these allegations came up and before Christopher was arrested and released on bond, was he active as a father in his relationship with his son?
Yes, he was very active with his son
Okay.
and his nephews.
Without naming the son, how old is his son now?
He's 9.
Okay. Do you have any reason to believe that Chris's son misses being around his father?
Yes, I do.
Do you believe that Chris's son would be better off if he was allowed to be around his father?
I believe he would.
Now, it has been posited that you're asking for permission for him to be around family on Easter Sunday only, but that's not what you're asking, is it?
I would very much like it for his nephews and his son to be able to visit, when the time specified. Because he was able to see his son on 3 times, every other week. He had cut overnight, weekend custody of him, and all that stopped when all this happened.
So are you saying that Christopher is subject to a custody ruling and he is not able to do what the family law judge wanted him to?
Correct.
No further questions to this witness, Your Honor.
All right. I have any questions unless there's some objections to the court asking questions?
No objection from the state.
Defense has argument. That's all that we have left.
Now, do you have any objections to me asking the witness any questions?
No objections, Your Honor.
All right. So I just have a few questions for you.
Okay.
Number one, do you know, and I'm not asking you about specific facts, but do you know anything about the nature of either of these cases?
I just know what was told to me.
Well, no. Just, do you know anything about the cases? That's yes or no?
Do I know anything about that?
Yes. Like, for example, what he's charged with, what are the alleged
Yes, I am.
ages of the children, who the
Yes.
children are?
Yes,
All right. Now, your counsel mentioned something about a custody agreement. Do you know when that custody agreement was put in effect, and has that custody agreement been modified since these allegations?
it has not been modified that I'm aware of, but he's making child support payments too.
But I mean, has visitation, other than this court's orders, have visitations been changed on the civil side?
I don't know, I'm not aware of that, but I just know that he hasn't, because of the no contact with under 17.
All right, then here's my other question, and you may not know the answer to this. Maybe the attorneys will be able to give this to me.
Mhm.
Do you know whether or not Child Protective Services was involved in this? In this
On my
case?
grandson's side?
No, just Was Child Protective Services involved at all in any of these cases?
I believe I heard that they were, yes.
All right, and did Child Protective Services do an investigation involving
They didn't.
your son and your grandson?
Yes, they did.
And does anybody know, or do you know what the outcome of that investigation was?
It was, yeah, you have that.
I am aware of most of the answer to that question, if I may.
Yes.
Okay, what I'm aware of is that after this allegation came down, that CPS did a preemptory investigation into my client's semi-custodial son, just to make sure that nothing had happened to the son. And my understanding is, I believe I've seen the documents to this extent, that that investigation regarding his son was closed with no reason to believe that anything inappropriate had happened regarding the son.
All right.
I'm not aware of any CPS actions involving the persons who are listed as complainants in these cases.
All right, thank you. Any other questions for the witness?
No, from the state.
All right, thank you. You may be excused. I'll call your next witness.
No further witnesses, simply argument.
All right, the court will hear argument.
It's his motion. I'll let him go
No.
first. Oh.
That's what I'm saying. Here, I'll hear argument.
Did you have anybody?
Well, no witnesses from me. And I'll have argument as well.
Your Honor, the wheels of justice have a bad reputation of turning slowly. We're here on something that may or may not have happened back in 2017. And it took 7 years for this to turn into a warrant. And a year later, we're still no closer to a trial. We very much look forward to using the system the way it's designed to be used, in hopes that it will shed the light of truth on everything. And our hope, my personal hope, as I believe my client, is that it will clear his name. We can't do that yet because the case is not indicted. And my client has been on house arrest, basically sentenced to prison in his own home, with the exception of working and a couple of hours for good behavior for a crime for which he has never been convicted. We have strong reason to believe that he has very meticulously complied with all of his conditions of bond. I have not heard the state bring up violations of conditions. The state has easy access to pretrial services. Had that been an issue, I'm sure the state would have looked there and gone there, and we would have heard about it. I've spoken with my client. He has gone over the top to comply with everything. He also has faith in the system, but he's also shared with me that it has been a very, very long year. And we're simply asking, as he has proven that he does not have to be kept at home at all times when not working, a preset job planned ahead of time, that he can be trusted with tracking only. Obviously, it's going to show where he is, but it's also going to show where he's not. I have no reason to believe that he has any desire to go anywhere near the persons listed as complainants in this case. And I've worked very closely with him and his mom and some other relatives in forming my opinions. Regardless of the outcome of the case, I don't believe that anybody is going to be at risk if he's changed to tracking only. He's given the court and the state more than a year and has been extremely patient at it. But it's time to recognize that, and recognize that we have more restrictions on him than what is actually necessary for the safety of the victims, the safety of law enforcement, the safety of the community, Your Honor.
All right, state.
Thank you.
Your Honor, the state feels that this is the exact type of charge where having no contact with minors under the age of 14 is appropriate, that the GPS conditions of partial house arrest should remain in effect until the judge sees differently while the case is pending. Given the safety of the community and the age of the children, we feel the bond conditions are appropriate and should not be affected in any way. Additionally, I have reviewed this with defense counsel. If he doesn't have any objections, they would like to enter into evidence Safety Exhibit 1, which is 1 page of the police report in this matter.
Defense understanding is that this is the narrative of the outcry to the first responding officer, but expects that the court will want to review that.
Oh, thank you. All right, so I have a few questions. And then maybe you all want to address this.
Yes, Your Honor.
And I understand about manpower. I understand all of this. But we were here on October 24th, 2024 for 2 cases that are CM cases. And we're still here on two cases that are CM cases. Obviously, it hasn't been taken to the grand jury. Maybe an investigation hasn't been completed. So when, if ever, I don't want to say if ever, when does the state anticipate moving this out of the criminal magistrate status? And if you're seeking an indictment, when will you be seeking that? Because we've been here on this case since last year, October, which I know, yeah, it's not that many months, but still, the alleged offense date, you say it's from 2017.
Yes, June 2017.
All right, on or about June 2017, and we're still here. And again, I understand manpower. State is saying this is important, but we're here.
I understand.
And I understand your issues because this is continuous, alleged to be continuous sexual abuse.
Yes,
So,
ma'am.
what is that?
Sorry, that was the show. I'm being quiet.
Oh, no problem. That's okay. I was like, wow, what information are we gaining? I thought it was information about this case.
To answer your question, unfortunately, I don't have a specific time frame to tell you of when and if this will be presented to the grand jury and when and if a potential indictment is coming. I just know that, as you mentioned, given the severity of the charge to first degree felony, state still feels that it is important to keep these bond conditions in place.
All right, so I can tell you what I'm going to do because I don't think it's fair for someone's life. He's saying he's not guilty. I don't think it's fair for his life to be in limbo forever. I understand the protecting of society. So this is what I'm going to do. I'm not going to rule on your motion. I'm going to recall this. And when we come back, state, you need to decide what you're going to do with this case.
Yes, sure.
And something needs to be done with this case.
Yes, sure.
I and counsel for the next hearing that we have, I'm going to want to see the civil documents
Family law.
with regards to his custody. I'm going to want the CPS, if they ruled it out, I'm going to want to see that documents or either have a CPS caseworker here.
Certainly.
The CPS caseworker can appear by Zoom. We're recalling this back on May 27th. That gives everybody plenty of time. There are weeks off in there for holidays for Fiesta. So I'm giving you all Fiesta time, but we're going to come back on May 27th.
Yes, Your Honor.
Your Honor,
Yes.
may I ask, given the fact that we're approaching 8 years, may I ask for some temporary orders so that Easter will not end up being a total loss?
I don't feel comfortable doing anything with your motion until I have the information on the CPS and also the civil custody matter, because I don't know if on the civil side, there were some modifications that were done there or not. So if I can have those documentations, we can go from there.
Thank you, Your Honor.
All right, so we're going to come back on May 27th. And at that time, state, you need to have an update for the defense and I will make a ruling.
Thank you.
Honor.
Thank you.
Is it inappropriate for us to ask for what you did for Thanksgiving and Christmas, considering that the court was comfortable granting that at that time? And
Well,
it is a major holiday.
well, I will tell you, the reason why I don't feel comfortable now is because there's been some CPS records that have been brought to my attention now.
Okay.
Yeah.
The no reason to believe, I believe I can email that to your office today.
All right.
You
Thank
can
you.
do that and we'll see where we're at.
All right. Thank you.
Thank you.
Ruben Maldonado. All right. And Bashan, this is an application and this is criminal trial division. Court is calling 2024 CR 011521. We're on the record, everyone. State versus Ruben Maldonado Jr. Can I have parties announced?
Jason Garaham for the state.
Renee Munoz on behalf of Mr. Maldonado.
And are you Mr. Ruben Maldonado Jr.?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, that's to both questions, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Maldonado, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor, we do so waive.
State, are you proceeding on the indictment as presented? Yes.
Yes, we are, Judge.
Mr. Maldonado, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right, everyone, if you could please not talk behind the court reporter, we're on the record. You're charged with evading arrest, detention with a vehicle. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent. Did you understand by entering into this plea, you are giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine? Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
In my opinion, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge, that is correct.
Mr. Maldonado, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, state recommends deferred adjudication. Did you understand that to be the plea? Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Judge.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 3 years. Did you understand those were recommendations from the state and the court does not have to follow those recommendations? Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? I'm sorry?
No contest.
State any evidence.
Yes, Your Honor. State Exhibit number 1 with all of its attachments.
No objection.
State you may be excused.
Thank you, Judge.
Did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you have applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
We're asking for this honorable court to follow the negotiated plea bargain agreement. Client has limited criminal history, I believe just 1 misdemeanor conviction for fictitious display. Other than that, no other charges, Your Honor. So we're asking that the court enter this deferred adjudication on behalf of my client.
All right, do you have any children?
1.
Age?
She is 13.
All right, does she live with you? Do you have contact with her? Which one? Does she live with you? Who all lives in the household?
Is me, my daughter, and my wife.
And who is Natalie Vanessa Perez? All right, so why are you all having marijuana in the vehicle?
She was carrying it. It was just,
And if you're drug tested today, what are the results going to be? And you need to be honest. I'm sorry,
I'll come back in.
when's the last time you used?
10 months.
And what have you been using in the past?
Marijuana.
All right, so just marijuana is not a good thing. You have a 13-year-old who's looking up to you. You understand? All right, how far did you go in school?
Have a great
What do you do for work?
do detailing.
All right, this is what the court is going to do. 3 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs, 100 hours of community service restitution. I'm going to order parenting classes. Once those are completed, the community service hours will be deemed satisfied. I'm going to field visits 1 time per month until further notice. Probation, please make sure probation texts on the children and investigate the home for drugs. Proof of employment within 30 days. No employment as a home health care provider or with minors. The reckless driving course and 60 sober meetings in 60 days. Probation, is there anything else? Is there anything else you need from the court in order to be successful? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. Your daughter's supposed to look up to you. You can't be doing this. And if your wife is a part of the problem and she won't stop using, then you're going to have to stand up and protect your daughter and cut those relationships. You understand? All right. In this courtroom, to be successful in probation, communication is key. If you have an issue, let your probation officer know about it. If you feel they're not addressing it, you can always come back and address it with the court. All right. Thank you.
Thank you.
All right. Are you all ready on Tyler Ketchum? Yes. And I will hand you the file back just as soon as I put it in the system. Oh, okay. All right. Are you all ready on Ketchum? Yes, he is.
Okay. So Judge, this was just a compliance hearing, so that Mr. Ketchum could give you an overall status on the treatment that he's receiving in Austin, if he's been placed into the program and so forth.
All right, Mr. Ketchum, if you can unmute for me, please. Hello, Mr.
Yes, ma'am.
Ketchum. Hi. So give me an
Hello.
update. How are things going?
Things are going well. I'm set up here at a new entry program with the VA in Austin. Working with Jolene Grzyzik, as far as getting into the Veterans Treatment Court.
Did they give you any idea of when you will be in the program fully?
They haven't yet. No, Your Honor.
All right, then what I'm going to do, defense, if you're able to let me know before this date that he is actually actively in the program, then this next setting date that I'm going to give you, we won't need to have it. What I'll do is I'm going to recall this case for, I think, May 20th, counsel. Do you think that'll be enough time for him to have been placed in the program fully?
Yes, I do, Your Honor.
All right, Ms. Abrams, we're going to recall this for May 20th. All parties can appear by Zoom again. And Mr. Ketchum, at that time, if for some reason you're not in the program, then your attorney will need to get information from the program of when they expect you to be fully engaged and admitted to that program. All right, thank you. I think his Zoom was bad.
Maybe so, but I apologize. I'll make sure he remains communicative with me, Your Honor. So we appreciate you.
All right, thank you so much.
Yes, ma'am. May we be excused?
Yes.
Thank you.
Oh. Yes. Okay, you can sign off. We're going to bring you back on May 20th and you can appear by Zoom.
Understood. Thank you, Your Honor.
All right, thank you. All right, sir, your attorney has a family emergency, so he can't be here. So we are going to recall your case for, Norma, you want to do this the week of May 12th? What date? All right, we're going to bring you back on the 13th. All right? All right, thank you. Hello, Dario Willers. All right, if you come forward. All right, on this case, where are we on discovery?
Judge, we're in the process of downloading all the discovery. I just talked to the state. We're still conferring, but I want to review make sure I have all the discovery, review with my clients, and then, see what happens.
All right, Ms. Ferguson, let's recall this for, normally these cases would have been set on Tuesday, correct? All right, let's recall it for discovery for May 27th. Is that good for you, counsel?
So Tuesday, yes, Your Honor.
All right, Norma, recall this for discovery May 27th. All right, thank you. Eugene Navarro, can I have parties announced for the record for the state? Defense?
Eric Bacon for the defendant, Your Honor.
And are you Mr. Navarro?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Are there any applications?
No, Your
Mr.
Oh,
Navarro?
Yes, Your Honor. Sorry.
There are?
Yeah.
Okay, I don't have an application. Did you all complete an application for probation?
Judge, I'm sorry, I didn't. I
All right.
apologize. I'll get that done.
All right, if you have a seat, they're gonna bring you up just as soon as that's done. Okay,
This is gonna be it.
no problem. Hello.
Judge, an extension status report was sent in for Ms. Lopez, asking the court to extend her a year to allow her to pay off restitution to Allstate. The original restitution was at an amount of $3,634. 500 of that was to be paid to a victim. That has been paid. $574 has been paid to Allstate. What is remaining on the restitution is $2,560. Ms. Lopez informed me that she has been employed maybe about 2 months. All this time she has been employed, but something happened with her job. She has completed all of the other terms of her probation and is reporting on time, and all is well with her drug tests.
All right, so here's my question. This plea wasn't taken by me because it was done in 2017 and I wasn't on the bench. So with regards to this restitution to Allstate, that's something should have been handled civilly. We have the criminal mischief that's to individual complainants and not to companies. So has the criminal mischief restitution been paid to the complainants in full?
Yes, Judge.
All right.
She is supposed to expire in approximately 1 month from today.
All right. Could I see someone from the state criminal trial division? All right. What have you learned from this?
I learned to take responsibility for my own actions, regardless of what's going on or what I feel was wrong of me or whatnot. At the end of the day, I'm in charge of my own self.
And what was this criminal mischief? What was this about?
I messed up a car, or I scratched a car.
All right. Was this over a guy? All right. Women. And let me ask you this, the car that was scratched up, was it the guy's car?
Mm-mm.
All right, so let me explain something to people. When you're in a
Well, I
relationship,
thought it was, but it was.
yeah, when you're in a relationship with somebody, if you think that person is cheating on you, guess what? The person they're alleged to be cheating with owe you zero loyalty. The person who owes you the loyalty is the person you're in a relationship with.
Oh, yeah.
And to avoid criminal charges, let me tell you what the best thing to do is. One, if you think somebody's cheating on you, you have a choice. Either I'm going to accept this or not. If you're not going to accept it, say peace, goodbye. I'm better than this. You understand?
Yes.
All right. So let's not do this again.
Oh, come on.
All right. I'm not going to extend her.
Yes,
She
ma'am.
has completed the restitution that was owed to the complainants in the case. I think she's learned her lesson. No more toxic relationships. Save the keys for the ignition. All right. Good luck to you. You're welcome. Parado Vidari. I know I butchered the last name. I'm sorry. Yes.
Good afternoon, Your Honor.
Good afternoon. So where are we on Discovery Council?
Judge, I've almost got all of it. There are some missing police reports from the date of the incident on this burglary of habitation case.
And is this criminal trial division?
It is criminal trial.
And have you spoken to them about
I
that?
have, and spoke to Andrew.
Okay.
Andrew's made an offer. We've rejected the offer. Andrew knows what I need. I'm sure that he will produce it expeditiously. Would like to be put on the trial docket for the burglary of a habitation case.
All right, this is what I'll do. I'm going to put you on the plea deadline docket because I want to make sure that you have all the police reports. Ms. Ferguson, set this for a plea deadline date, May 13th.
Thank you, Your Honor.
And state at that time, make sure he has all the discovery. You all be prepared to sign a discovery acknowledgement. And sir, on that date, you need to let the court know whether or not you've reached an agreement with the state. If you have not, your next court date will be a jury trial date. Do you understand?
Yes, ma'am.
And counsel, if you can discuss with your client and discuss with the state whether you would like a bench trial or a jury trial.
Will do, Your Honor.
All right. And what I can tell you, if you come to me for a bench trial, if the state proves their case beyond a reasonable doubt, I'm finding you guilty.
Well, I was overhearing you what you said right now about the women being in a relationship. That's all this has to do is.
No. Here's the thing. Don't plead your love case to me. All right. All right. Good luck to you.
Uh-huh.
Malik Hatch. Yes. And counsel, you're on this side. Hi. Good afternoon. So where are you all on discovery?
Discovery has been tendered. Have you received it?
Yes,
Okay.
we've received the discovery, Your Honor. We're conferring right now.
Okay.
We are thinking about applying to the mental health court.
Okay.
We're in discussions about getting more information to the state of this.
All right.
And Judge, just as far as we did confer today, counsel's gonna provide me with something, and then I do need a little bit more time to speak with the complainant before I can officially make an offer.
All right. Is May 27th enough time for everyone?
Yes.
And I think that'll give people time if they're thinking about the mental health court to find out if he's going to be accepted. All right, we're going to bring you back on May 27th. Thank you for dressing appropriately for court. Once you sign the reset form, you're excused. You're welcome. Ms. Ferguson on Hatch, that's May 27th, and you can put it down as a discovery. If you'll speak with defense counsel and see if they want a referral to the mental health court. Ramiro Guzman.
So it's an MTR and a new number one. They don't yet have the MTR available, and I've been conferring with the state. If we could just recall it for a couple of days, I do know that the state and I can finally get the MTR, work it all out, and come back with the paperwork done.
Well, what I can tell you is next week I will not be here. But if you want a judge who will listen diligently to your arguments and make a just decision.
To the defense. right?
That's not right.
Oh, you should have been muted on that.
Yeah, no, he will. Or either I can bring you back on the week of May 5th. Is that enough time for you? Ah,
They've been trying.
And we're trying to get it approved.
all right. So do y'all want to recall it for tomorrow?
That's fine.
All right, Ms. Ferguson, Guzman, recall tomorrow.
Okay.
All right, Norma, on Jody Flores, defense counsel is ill. Are they on bond? Counsel, if you come up with your client,
Yeah,
on Mr. Navarro?
I'm pretty sure we're ready. Just tense.
All right. We're back on the record in 2025 CR 001680, State versus Eugene Navarro. All right, who's here on Christopher Ray Munoz?
President, Your Honor.
All
Ben
right,
Stevens for the defense.
all right, if you'll have your client come up and counsel, you're on this side.
Refer me yes to the approach.
Yes, Your Honor.
All right, and if parties could re-announce, please.
Andrew Harris, Salem, State.
Eric Baker, the defendant, Your Honor.
All right, where we left off, Mr. Navarro, did you review the document entitled Application for Deferred Adjudication with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, Judge, waiving count two.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand in count one, you're charged with the offense of assault of a peace officer or judge as a second-degree felony? Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine.
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your agreement. If for any reason the court does not follow your agreement, gives you more than you bargained for, the fact that you enter a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, I did, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, is your client applying for deferred adjudication or no?
Regular probation.
All right. Counsel, has your client been able to provide you with any defenses?
Yes, he has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Mr. Navarro, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 10 years in the prison. The state is recommending community supervision and they're proceeding on count one. Did you understand that to be the plea?
Yes, I did, Your Honor.
Defense, is that the plea?
Yes.
State, is that the plea?
Yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Judge.
Outside the agreement, the state is recommending a TAP evaluation and that your community supervision be for a term of 10 years. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offense as charged in count one, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State, any evidence?
Contained in Exhibit 1 and attachments.
No objection, Judge.
All right, and state, have you spoken to the complainant?
No, Judge.
All right, you may be excused. Did you review the waiver and consent to stipulation with your attorneys? Did you understand it and did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports but most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We would ask to judge, yes.
Anything you wish to say on behalf of your client?
Yes, Your Honor, just briefly, my client had told me that he, as part of his probation, is requesting inpatient treatment for his alcoholism. Feels it's the basis for not only this problem, but some of his past problems. That was a specific request. He wants to do that. He's motivated to do that, and asked that you make that a part of his conditions of probation.
All right. Do you have any children?
No, ma'am.
Do you have any family support here?
No, ma'am.
All right, so who are your relatives?
Well, yes, my grandma, she's a supporter. That's where I go and stay at.
All right. How far did you go in school?
I went to the 8th grade, ma'am.
All right, so when's the last time you had employment?
Employment was it's probably about half a year ago, a year and a half ago.
All right, so why did you drop out of school? What happened?
I dropped out of school because I was failing classes and I was already too old to be in school. So that's when I decided to drop out.
All right, what do you mean you were too old to be in school?
I was gonna be 18 in the 8th grade.
Okay. All right, so were you in any type of classes, disability classes or anything like that?
Yes, I went to GED classes, but what happened is the school did close down on me. So after that, I got a little bit discouraged and I just been trying, looking for work back in the streets, like odd jobs.
All right. And so, and I'm just trying to find what level you're on, because here's the thing. All of us start at a particular place where we're constantly learning and growing. So I'm trying to understand some things about you so I can make conditions that are conditions that you can be successful at as if you try, all right?
Yes, ma'am.
So do you have any problem with reading or writing?
No, ma'am, not at all.
Okay. All right. This is what the court is going to do. The court will sentence you to 10 years in the prison, suspended and probated for 6 years. There's going to be regular reporting by Zoom or in person, regular random UAs. This is what I want done in custody. I want a referral to felony drug court, a TAP evaluation. And Ms. Abrams, if you could let probation know that he dropped out at 8th grade, please, so they'll be aware. There's going to be 100 hours of community service restitution. You can either do the community service hours, or you can work on getting your GED or trade school certification. I'm not going to order you to get your GED or trade school certification. I'm going to give you a choice. Either you can do the 100 hours, which will be in the heat, because it's San Antonio, or either you can do the GED or trade school.
Yes, Your Honor, thank you.
And I'm going to want 90 sober meetings in 90 days. Anger management course. Proof of employment within 30 days. No employment as a home health care provider with minors. And probation, he may need some kind of employment help, because I don't know what skills he would have. Field visits 1 time per month until further notice. And that's just to keep you on track.
Yes, Your Honor.
Probation, is there anything else he needs? Anything else you need from the court to be successful?
No, Your Honor.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question about that, you need to speak to your attorney. You understand?
Yes, Your Honor.
All right, we can go off the record. Here's the thing. You've been living your life the way you've been living it for a long time. So this is going to be a difficult probation for you to maintain your sobriety, right?
Yes, Your
In this court, if you think you're going to use in this court, only in this court, I don't know what other courts are doing. The best thing you can do is pick up the phone and call your probation officer and say, I need help. I feel like I'm going to use. If you feel as though they're not addressing it, if I'm here, you come back to court, you tell me, I think I'm going to use, and we'll take care of it. But if you do one of these things where you go on a bender and you're missing, all bets are off. I'm just gonna do whatever comes my way. You understand?
Yes, Your Honor.
All right, good luck to you, okay?
Thank you.
Thank you,
Judge.
counsel.
Good to see you. Maybe excuse.
Yes.